Thank you, Ernst. Thank you, AfriForum, for the opportunity to present here today on the prevalence of race law in South Africa, and thank you all for making the time to attend. I must start by defining my capacity here a little bit. I am here as the head of policy of the Free Market Foundation, which is a classically liberal advocacy group that was founded in 1975 to promote individual liberty, private property, free enterprise, and limited government. Now, the index of race law, which I constructed and maintain, however, I do on behalf of the South African Institute of Race Relations, which is also a classically liberal entity and one of the oldest such institutions in the world. The Institute of Race Relations, or IRR, was founded in 1929 precisely to add a counter-narrative to the racial orthodoxy that existed at that time. So relying mostly on data and credible investigations, the IRR was able to show that race law was a folly. It simply could not work. And this advocacy almost led to the abandonment of the United Party segregationist policies in the late 1940s. The government of the day, however, was quite infamously changed and replaced, and race law continued to grow for another half century. The Free Market Foundation, meanwhile, founded in 1975, arguably at the very apex of what is known as apartheid. This was shortly before reforms away from race law, in fact, began in South Africa. And the FMF's singular goal back then, as it is today, was to argue for why a free market capitalist economy, a growing economy, is preferable to the authoritarian regimentation that boxed most South Africans into inescapable parameters back in those days. Both of these organizations are fiercely dedicated to the principle of non-racialism and have been before, during, and after apartheid. So I need not watch my step today with my dual role here. Now, one of the very simple purposes that I have here today is to show that race law is alive and well in South Africa. Now, I think everyone in this room would think, well, duh. But surprisingly, there are still some South Africans who deny this reality. And unfortunately, many influential, well-read people around the world also do not know that after 1994, legislated racial discrimination, in fact, did continue in South Africa. So I hope this slide, which is my only slide, can put that fantastical notion to bed. But before I get too ahead of myself, we have to begin by answering the most basic question applicable here today. What is race law? But let me take another step back. What is the common law? The common law are those legal rules and understandings that have been recognized, applied, and refined over centuries by successive generations of judges and jurists. Common law rules do not materialize and cannot materialize out of thin air by legislative decree, but must be based on the reasoned application of pre-existing legally relevant principles. Well, at common law, there is no such thing as race. The common law distinguishes between natural and juristic persons as legal subjects, so that is individuals and corporations, and it does at times distinguish between men and women. There is no common law of race. Under all circumstances, a person's skin color is irrelevant in the common law. So for race to be legally relevant, one usually requires a statute, which could be a constitutional statute or a normal piece of legislation or an executive regulation. For the purposes of the index of race law, a statute that makes a person's race, skin color, or ethnicity relevant, legally relevant is regarded as a race law. So the index was last updated on the 24th of October 2023, that's last year. So all references to its current state will be to that date, and as far as I am aware, no new race law has been adopted since then. As of then, there were 141 acts of parliament on South Africa's statute book that may be regarded as race law. Now in total, since the Union of South Africa was created, as Ernst mentioned, Parliament has adopted 313 racial statutes from 1910 to the present day, and 37%, or 116 of those, were adopted during and since 1994. Of course, many of the 313 statutes have in fact been repealed. They are no longer operative or active law. But as we stand here today, there are 141 acts of parliament on the statute book that make race or skin color relevant. And that is an astounding 45%, almost half of all the race laws that South Africa's parliaments have adopted since it came into being. That is an astounding number. So a clear handful of these are pre-1994 acts, and I will get to why that is relevant and potentially misleading in a moment. But first, some interesting notes from these numbers. During apartheid, the year 1980 was the year in which the greatest number of racial acts of parliament were present on the statute book, being 123 race laws. And you can see that there, that is the peak there before the dip. The very peak there is the year 1980. Since 1980, the number of racial acts of parliament began steadily declining, and you can see that there as well. And this reflects the National Party government in its reformist phase. All the orange, the big orange peaks you can see at the bottom there, those are race laws being repealed, and that happened in large numbers throughout the 1980s. That was the reformist National Party. So racialized legislation on our statute book reached its lowest point in 1996, which was when there were only 52 racial acts of parliament on the book. That is the closest we've ever gotten to a period that we might today refer to as the good old days, 1996. And that is that very bottom here. That is the good old days of non-racialism in South Africa, if you could say that. But since 1996, the number of race laws has increased dramatically, with 1998, which is only 2 years later, being the absolute worst year for raw numbers of race laws adopted in South African history. And that is this blue or teal peak right there. So 20 racial acts of parliament were adopted in 1998 by the new democratic, so-called democratic legislature. The year with the second highest number of race laws adopted ever in our history is the year 2000, with 17 acts of parliament that make race legally relevant. That is the next teal peak after 1998. So coming in third place with only, and again I say only in inverted commas, if it weren't obvious, with only 9 race laws adopted during that year is 1976. So 1976 is the year during which the apartheid government adopted the most race laws. And 1998 and 2000 are the years during which the democratic government adopted the most race laws. In the year 2007, we reached the peak of 1980 again, with 123 racial acts of parliament in total on the book. From there, it climbed to where we sit today, with 141 parliamentary race laws that might be described as operative or active law. Now, ladies and gentlemen, just getting back to how laws are classified as either pre-1994 or post-1994, the index of race law, constructing it was something of a complex exercise. The complexity might be why the index is the first initiative of its kind in South African history. And this, when this initiative was started, astounded me. South Africa is a global mecca of race law, and it has been for at least a century. And yet no attempt has ever been made during that time to account comprehensively for race law on the book. Some work was done by the Nelson Mandela Foundation after 1994 on pre-1994 race laws, but it did not even scratch the surface, and it only listed what might be called the big apartheid laws that everyone would know about. After 1994, Professor Koos Malan and Dr. James Meyerberg also did some useful work in accounting for the significant race laws of the so-called New South Africa, but these exercises also missed a lot of the call them less notable race laws. And let me tell you, finding all the race laws was by no means an easy feat. Even now, it is possible that the index is missing some racial acts of parliament, but I think I can say with a fair degree of confidence that it has captured at least almost all of them. But if you try to engage with the index, you must do so holistically. Doing so half-heartedly might give you misapprehensions and misimpressions of the reality of race law in South Africa. So allow me to provide you an example. The Insolvency Act was adopted in the year 1936, 1936. That is before apartheid, but still during the United Party's segregationist era. It was then a non-racial Act of Parliament. However, in the year 2003, that is just the other day, the Insolvency Act was racialized through an amendment. And this act of racialization, however, does not change the fact that the Insolvency Act is an act from 1936 that is a race law. In other words, the Insolvency Act is counted as a pre-1994 race law in the index, even though it was only racialized after 1994. So yeah, there's one thing to note. The other relates to double counting. There was, for example, some confusion recently around the Employment Equity Amendment Act. For those of you who do not know, this Amendment Act obviously amended the Employment Equity Act, and it significantly worsened the racial aspects of that law, and it certainly expanded the Minister's power, the Minister of Labor's power, to engage in discretionary racialization. Some people believe that this amendment, given just how severe it was, should therefore have been counted as another race law, and therefore 117 race laws have been adopted since 1994. And I can understand that reaction, it makes sense. But the index excludes amendment acts because it has to. An amendment act in 99 out of 100 cases, and there are exceptions and they are in the index, only introduces new law into an already existing act of parliament. To count both the act that is being amended and the act that is amending it would mean that one race law is counted as two. And if we did that, we would significantly be overstating the extent of race law in South Africa. This graph would look totally different. So race law in South Africa is bad enough as it already is, so we do not need to jummy the numbers. So whenever there is an amendment act that racializes a non-racial act, it is counted as just one race law. And whenever there is an amendment act that further racializes an already racial act of parliament, like the Employment Equity Act, it is not counted at all. The index explains these and other quirks and does not try to hide it or exploit them for shock value. But as I said, one must look at the index holistically when using it, and all the relevant information is provided. So the Index of Race Law is not currently a funded project, which means that development is slow going, and at the present the index only records and monitors acts of parliament being legislation adopted by South Africa's central parliament based in Cape Town. But that is not the only place where race law exists in South Africa. Our provincial legislatures have original constitutional authority, and they might have adopted racial provincial acts. And our municipal councils have original constitutional authority and might too have adopted racial bylaws. Our courts, I know for a fact, have handed down racial judgments, and these too are race laws, but they are not currently factored into the index. So if anyone here or any of those watching at home are interested in helping the index move into its next phases to comprehensively account for all race law, please do not hesitate to get in touch with me. Now at this stage I must emphasize that the Index of Race Law is intended to be a tool for everyone. It does not, at least not explicitly, pass judgment on the desirability or not of race law, and it does not attempt to qualify the harm or the good that any given race law might be doing. At least in its current state, the index is not an analytical tool, but only a database of information. That being said, that does not stop me or anyone else who utilizes the index to use its information for further analysis, which I will now very briefly do. In 2001, a book titled The New Apartheid appeared, written by Sizwe Mpofu Walsh. The subtitle of that book is Apartheid Did Not Die, It Was Privatized. So Sizwe Mpofu Walsh is a race hustler of note, and this is by no means a new idea from him. in the late 1980s and the early to mid 1990s, and thereafter, certainly today as well, people like L.B. Sachs, who went on to sit on the Constitutional Court, and Dennis Davis, who is still around simultaneously as a judge and a political commentator, yikes, made similar observations. In their view, it would have been unacceptable, and it certainly to them is today unacceptable, that one might still find ostensible racial imbalances in the private sector. To them, this is simply apartheid continuing by other means. In my view, the first part of Sizwe Mpofu Walsh's subtitle is correct. Apartheid did not die, at least not entirely. But the second is also true, but only partly so, and certainly not in the way that Mpofu Walsh, Dennis Davis, and L.B. Sachs might believe it to be. The racial categories of the infamous 1950 Population Registration Act continue to exist in law in this country, despite that law being repealed in 1991. They were incorporated into our law by reference in terms of the 1998 Employment Equity Act. This hallmark law of apartheid, which is said to have defined that system, the Population Registration Act, remains law by reference in South Africa today. So therefore, apartheid did not fully die. But how indeed has apartheid been privatized? Well, a significant dimension to race law, and I would say perhaps the most significant dimension in post-1994 South Africa, is self-classification and self-enforcement. This is true for the really harmful race laws, like the Employment Equity Act, like the Preferential Procurement Policy Framework Act, and like the Broad-Based Black Economic Empowerment Act. Without voluntary buy-in from the private sector, with some exceptions, these race laws would have been born as dead-letter law. The less harmful stuff, like representativity, is enforced by government. And I must add that most post-1994 race laws, by far, are concerned with representativity. So what is representativity? Well, it is a provision in an act or in a regulation that requires that some government board, committee, council, or some other body reflect the racial demographic makeup of South Africa. The Constitution itself alludes to requiring representativity, but that is a very big topic for another day that I will not get into. While representativity is, I think, very important to many people, as a classical liberal myself with a healthy dislike of anything and everything to do with government, especially given the collapsed state of South Africa's government today, I am not so sure that representativity really matters that much. Yes, representativity is used as a way to appoint friends and family to powerful positions in government and to avoid questions of merit and qualification. But I promise you, if there was no representativity requirement, or even if it was reversed, if the government was compelled to appoint a disproportionate number of white South Africans, the ANC would still have been able to find perfectly incompetent white friends to appoint onto government bodies. So our state is collapsing not due to representativity, but due to a government that is not only criminally corrupt, but ideologically corrupted as well. The real harm then is not in the hundreds of race laws that require public sector representativity, but the small number of handful of race laws that I have already mentioned that require private sector representativity, although it's not called by that name. There are laws, these are the laws that encourage business owners to make racialized employment decisions, and in many instances require private sector actors who provide necessary goods and services to the public on behalf of government to be racially evaluated. This is the privatization of apartheid. Even though, if you ask me, as someone with a bunch of law degrees, there is no provision in the Constitution that allows government to enforce racial regimentation in a private entity. So allow me to conclude on an important note, ladies and gentlemen. We have to be conscious of the fact that the race law that existed prior to 1994 was significantly more harmful to society than race law after 1994. And this is for two reasons. The first reason is that pre-1994 race law was significantly more fundamental to everything: the society, the economy, religion, politics, law, and so forth. Post-1994 race law is doubtless far more peripheral and cosmetic, although every year or so it gets even more fundamental and more harmful. Soon, as Ernst already mentioned, independent estate agents who have too pale a skin complexion will simply not be able to do business. So it is getting worse. The second reason that pre-1994 race law was significantly more harmful than today is that the pre-1994 government was significantly more effective and a competent institution. With some notable exceptions, whenever that government decided that it wanted to implement a policy, it simply did so. The post-1994 government is an incapacitated, inept, and inefficient mess that cannot deliver on even the most basic functions that governments everywhere are arguably responsible for. The result is that the pre-1994 government implemented its racial policy quite effectively, again with some exceptions, which made its racial policy more harmful. And the post-1994 government is almost entirely unable to implement its racial amongst all its other policies, making it less harmful. Small mercies, ladies and gentlemen. But though we acknowledge that pre-1994 race law was a more harmful institution, that does not excuse the many race laws that we live under today, because race law per se is anathema. We are constantly told that pre-1994 race law was a more malicious, but post-1994 race law is justified because these race laws are intended to repair the injustices of the past. But intention can never be as powerful as the defenders of race law today seek to make it. Here, I am not only talking about the consequences of post-1994 race law, which have been very detrimental to our socio-economy, but I am talking about the very nature of race law and the very nature of intention. Pre-1994 race law was not malicious. It was authoritarian, it was collectivist, it was ill-considered, it was misguided, and it had absolutely disastrous consequences. But it was not ill-intended. Apartheid was a crime against humanity, but it was one of criminal negligence and not one of criminal malice. The architects of pre-1994 race law believed in error that racial engineering was the only viable solution to the clash of cultures. Like so many today believe as well, the planners of former years believed that they could successfully design a society from the comfort of political committee rooms, without harming anyone's vital interests in the process. They were wrong, and we cannot today ignore just how wrong they were. We have to learn from their mistakes and do our very best to address the consequences of those mistakes. And the best vehicle to do that, of course, is a free market economy. Post-1994 race law is also not malicious, ladies and gentlemen, but its good intentions do not save it any more than the good intentions save old race law. Understanding intention is very important for a holistic understanding of history, but in matters of public policy, when intention does arise as a factor, the only relevant question is, who cares? Race law per se, despite any intention to the contrary, is disastrous for everyone's interests. But race law is also fundamentally offensive to any good understanding of law and constitutionalism. Race law conflicts with the most basic assumptions of the rule of law. And one of these assumptions, or indeed requirements of the rule of law, is that the law may not and must not require the impossible. In 1971, if you wanted a good Western education for your child, you had to be white. Nobody can change their race. Today, in 2024, if you want the last available spot for a medicine degree at a premier university, you have to be black. Nobody can change their race. This biological fact did not change since the 1970s. Race law requires the impossible. Not the improbable, not the unlikely, but the impossible. Race law uses something over which people have zero control, the color of their skins, against them. There is nothing anyone in a disfavored racial category can do about their lot other than finding ways to circumvent the race law that undermines them. This is called fronting, it's called fraud, and it's called undermining transformation. But if you ask any legal thinker who truly understands the purpose of law in society, this is called necessity. Thank you.